All right, let's get into it. Today, we're unpacking a story that kicks off with something a lot of us can probably relate to, a super frustrating parking ticket from an HOA. But trust me, this is not your average neighborhood dispute. This is a case that took a very sharp legal turn and, well, it ended in a way that I don't think anyone saw coming.
And that's the big question we're tackling today. You've got a homeowner. He's convinced he's in the right, so he takes his HOA to court to prove it, only to have the whole thing tossed out before it even gets off the ground. How does that happen? Why? Well, the answer pulls back the curtain on a crucial lesson about the law that, interestingly, has almost nothing to do with who is actually right or wrong.
So, let's meet the players in our story. On one side, we have the homeowner, Thomas P. Hommrich, and on the other, the Lakewood Community Association, his HOA. On the surface, it seems pretty straightforward, right? But as you're about to see, the devil is always in the details. Okay, so here's the spark that lit the fire. On March 9, 2023, Mr. Hommrich files a petition. His argument is simple. The HOA is ticketing him for parking on a public street, and he believes they have absolutely no authority, no control over that public street. He's saying they basically have no legal leg to stand on.
Now, this is a direct quote from his court filing, and you gotta lean in here because the exact wording he uses is everything. He wasn't just asking for his ticket to be waived. No, he wanted the court to issue a formal order to prohibit the HOA from doing this to anyone ever again. And that one specific request, well, it turned out to be the fatal flaw in his entire case.
So the HOA gets this petition, and their response, honestly, it was a strategic masterstroke. They didn't even bother to argue about the parking ticket itself. Instead, they attacked the very foundation of the lawsuit, basically arguing that this case had no business being in court in the first place. And boy, did things move fast. After that first filing in March, the real action exploded over just 2 days in May. The HOA files a motion to get the case thrown out. The very next day, the homeowner fires back with a response, and on that same day, the HOA lands the final punch with its reply. It was a legal chess match played at lightning speed.
Okay, so to really understand what happens next, we have to do what the judge did. We have to go right to the source. We need to crack open the HOA's rule book, what's officially known as the Covenants, Conditions, and Restrictions, or CC&Rs, and find the one specific rule at the heart of this entire storm. And here it is. This is the exact text the HOA pointed to in court. Now, it starts by saying the goal is to get rid of on-street parking. But the killer phrase, the part that completely turns this case on its head, is that last sentence. The association may adopt additional parking, rules, and restrictions. Let's talk about why those words are so powerful.
That phrase is the entire foundation of the HOA's argument. It's the magic wand. By saying the association may adopt additional parking rules, the community's founding documents gave the HOA the explicit power to create new rules that weren't there in the beginning. So you see, the homeowner wasn't just fighting a ticket anymore, he was challenging the HOA's fundamental power to govern the community.
And this all leads us to the verdict. On May 19, 2023, just 10 days after that rapid-fire legal battle, the judge, Velva Moses Thompson, issued her order. But she didn't rule on the parking ticket. She just dismissed the homeowner's entire case. Threw it right out. And she did it for two very, very specific reasons.
Yep, just two. That's all it took. The judge laid out two simple but incredibly powerful legal arguments that completely dismantled the homeowner's complaint. Let's dig into the first one.
The first reason goes right back to that rule we just saw. See, the homeowner's argument wasn't, hey, the HOA broke Rule 4.2t. His argument was, the HOA doesn't have the power to make these rules at all. But since the document explicitly gives them that power, he wasn't actually claiming a violation of the rules. He was challenging their right to exist. Which brings us to the second, even bigger problem. And this right here is the absolute core of the issue. The homeowner was asking for something called injunctive relief. It's a fancy legal term, but it basically means he wanted a court order that would force the HOA to stop what it was doing. The problem? He filed his case in the wrong place, the Office of Administrative Hearings, or OAH. You can think of the OAH like a referee in a football game. It can call a foul if it sees a rule being broken, but it can't rewrite the rule book or kick a team out of the league. He was asking a referee to do a commissioner's job.
This whole thing boils down to a critical legal concept called jurisdiction. And honestly, the best way to think about it is this. You would never call the fire department to order a pizza, right? They're wonderful people, but they don't have a kitchen, they don't have pepperoni, and they don't have the authority to sell you food. They lack jurisdiction. The homeowner, in this case, took his order for injunctive relief to a court that simply wasn't on the menu.
But wait, the story isn't quite over. The homeowner didn't just walk away. After his case was dismissed, he filed a motion for a rehearing, which is basically asking the judge for a do-over. So how did that go for him?
Well, he immediately slammed into another procedural wall. The same court, the OAH, said, sorry, a final decision has been made, our hands are tied, the case is closed here. All they could do was forward his request to a totally different agency. He was stuck in a maze of legal red tape, and the mistake just kept following him.
So what is the big lesson here? This entire case, from a simple parking ticket all the way to a full dismissal, is a masterclass in one of the most important and, frankly, most overlooked parts of any legal fight, procedure. And here's the ultimate takeaway. It doesn't matter how right you think you are if your legal strategy is wrong. The what, the substance of your complaint, is really only half the battle. The how and the where you file your case are just as critical. You have to file the right kind of claim in the right court and ask for something that court actually has the power to give you. In this situation, a request for that powerful injunction probably needed to go to a superior court, not an administrative office. That one procedural mistake made his entire argument totally irrelevant. And that leaves us with this final, fascinating question. This homeowner may have genuinely believed his HOA was totally out of line, but because he wasn't in the right legal place, his side of the story was never even heard. It really makes you wonder, in the complex world of the law, what actually matters more? The justice of your cause or the mastery of the process?